Conference off by introducing Dean Nick Allard, the Dean of Brooklyn Law School, to welcome everyone.
Well, it's great to see you all here on a cold Friday. We've got a hot topic for a cold day. I don't think any of you will be tempted to venture outside while the program is going on. You know, one of the many joys of becoming part of this scholarly educational institution in the heart of the great city of New York is to, say, be part of a faculty where when they're having a conversation, they use a word like oeuvre 3 times. They actually say that word out loud. I wasn't quite sure. I mean, I'm a very naive person. That was not one of the words that I spoke out loud, or like naive, the same thing, I think. You know, traveling recently up to see a play with Patrick Stewart and other superstars, and suddenly discovering that I've been pronouncing Godot wrong the whole time, and it's now Godot. This is a real educational experience, and now I'm learning what UNCITRAL means, which will be a centerpiece and topic of today's conversation. This program today represents the best of Brooklyn Law School, both our traditions and changes and new things. The tradition here, like many other stories, starts and traces back to the late Barry Zaretsky 20 years ago. Was in a very ambitious and initiative full of foresight, launched a program in a major symposium shortly before his untimely death, addressing questions of international insolvency, international bankruptcy, appreciating that the world was one becoming increasingly with porous borders and that markets were global, and that Symposium, the global village, was a really remarkable scholarly endeavor and was generated the largest volume, and the articles in that volume from the Symposium remain classics in the field. Then 10 years later, Professors Janger, Professors Gerber, and our Professor Neil Cohen. By the way, Neil Cohen has been winning so many Lifetime Achievement Awards. He got a note of jealousy from Meryl Streep recently. They reprised that symposium. They took stock of the accomplishments of the intervening 10 years. And the result was a volume that remains the largest volume of the Brooklyn Journal of International Law ever published. And again, the themes raised in the articles remain central to today's conversations. The continuity really continues with today's program. Jay Westbrook, Michael Gerber, Gabriel Moss are here, and they've participated in all 3 symposia. Ted Janger, John Podow, and Christopher Paulus, and Don Bernstein have all participated in previous Brooklyn Symposium. Now, this 3rd symposium is addressed to conflict reform efforts currently underway at UNCITRAL and promises to continue the Brooklyn tradition of producing and publishing scholarship of the highest quality that matters. And we're looking forward not only to the conversations today, but the scholarly works and publications that ensue from this event. Now, that's the tradition and the continuity. But Brooklyn and this law school has certainly been, and in this field, a place of change. The Brooklyn Journal of Corporate, Financial, and Commercial Law Journal is only in its 7th year, and it's quickly become one of the top 10 corporate law journals in the country. This reputation is due in significant part to not only the quality of its annual symposium, but the incredible hard work of the student editors and their supervisors who put together today's program. And they'll be continuing to work closely and gently over the course of the next year to produce the published volume that we expect and look forward to. In particular, I'm recognizing the journal's symposium editor, Lauren Yunkins. Lauren, where are you? Are you around? There you are. Lauren, just stand up and get a round of applause here. Now, the symposium co-sponsors the Brooklyn Law School Center for the Study of Business Law and Regulation, which is in its 2nd year. And this new center is the brainchild of the Balin professor here at Brooklyn Law School, James Fanto and Professor Ted Jangers, and it seeks to unify the various commercial and corporate law programs at this law school. And this includes the journal, this symposium, the Zaretsky Bankruptcy Roundtable, which is an extraordinary event every year, and a new program in financial services compliance. I'm also particularly grateful that Ted and Jim have proven themselves as remarkable fundraisers, along with Professor Gerber. Now, he served some time as a dean here, so he's dirtied his hands a little bit with fundraising, but Ted and Jim have shown extraordinary success in finding support from our advisory committee and other alumni and others for this important program. Now, third, I really highlight with some gratitude our International Insolvency Institute co-sponsor. The III, the III, has provided generous financial, substantive, and for all of you who were at last night's dinner at 21, gastronomic support to this event. I'm going to be pumping aspirin all day because instead of being at your event, I was at the very, very boisterous auction last night for the Bankruptcy program. The decibel level, I think, was about 250 or something. It was really kind of extraordinary. So when I say that I really missed being with you, that is a quite genuine sentiment. So a key to producing this law school-based program that matter to the profession is the partnership with organizations like III, not only because of the very significant financial support, but also because of the guidance to make sure that there are real practical implications of the very important research and scholarship that we're doing. We are putting on at this law school an enormous number of quality events, programs with new academic initiatives. This is only done because all hands are deck are performing at such a high level. In particular is our events staff, all of them who we are very, very grateful to for their work, and we appreciate everybody from our media and tech people back in the corner who are helping us memorialize this event to all of our event staff. So thank you all very much, and Bruce, I'm going to turn over the microphone to you at this point. Thank you all for coming.
Thank you, Dean. It's good to see everybody here this morning, and I would like to express our appreciation to Ted Janger for offering the III the opportunity to participate in the event. It's not often you get this much talent on a particular faculty, but for those of you who aren't involved in the area or not familiar with the area, this faculty is about as good as it gets anywhere. So Ted has put together a fabulous team for the program today, and the III is proud to be a part of it. For those who may not have come across the III previously, we're a nonprofit organization. Our objectives are to improve international insolvency systems and procedures, and it's quite a task, but we've been at it for 10 to 12 years now. We started modestly, but the III is now represented in 55 countries around the world by members whom are individually selected, and we think they're the best people in the world in their area in the insolvency field. We hope to make a contribution to continuing to improve international insolvency systems and procedures through fora like this. And I'm pleased to note that most of the faculty today, I believe, without counting, are members of the III. So I appreciate everybody from the III who's taken the time to prepare and be with us today. It's going to be a fabulous program. So I'll let Ted take it over from here, and we're going to have a wonderful day. Thank you very much.
For anyone who knows me, even welcoming remarks have a PowerPoint. So thank you, Dean Allard. Thank you, Bruce, for incredible support for this event and for the enterprise of international bankruptcy over the years. I think this is going to be an extraordinary conference in large measure because this is a group that's been talking about this stuff for a long time, and we've really sort of arrived at a pivotal moment in the conversation. I want to doubly thank, somewhat in the past and somewhat in advance, the Brooklyn Journal of Corporate Commercial and Financial Law. Did I get it right? I put it wrong in my slide. Financial and Commercial Law. I made up the title of the journal. That's not good. It's also a bad title for a journal, but never mind. Long story. The editors are here. For those of you who have already, one of the things that's extraordinary about this conference is, and this group, because you've done it before, every time I organize a conference, you're always hurting people to get in their papers. And this group turned in their papers, some early, most on time, pretty much all within the window of appropriately on time, and they were on point, substantive, and they're in their volume. You can check it out. But they know, and you all know, that the work is halfway done today. The next start is going to be to turn those drafts into law review articles, which both take into account what's happened today and, to a certain extent, take into account what happens in this area over the next couple of months. And the journal editors who are here will make a point of meeting you guys so that you know who's working with you on your articles. Okay. So, as I said, the papers today, I read them, they're spectacular, and they assure me of my hope for this conference, which is both that it would be an excellent scholarly conference, which would produce a good volume for the journal, and an expert group meeting that would produce useful discussion for UNCITRAL and ongoing law reform efforts. If we can pull both of those two things off, we've done something really quite remarkable. So a little bit of context. As Dean Allard pointed out, this is the third cross-border bankruptcy conference at Brooklyn Law School. When this effort started, there were no international instruments. Now there are several that are well developed, and broad areas of consensus have emerged that no one would have viewed possible when Barry Zaretsky first organized. I didn't know Barry yet. I didn't know Barry. But when Barry first said, let's have a conference, and we've gotten to a point where the devil is now in the details. By the way, I brought a demonstrative aid. This is the second book. I mean, this is what we produced the last time. I only have 3 copies, otherwise I'd hand them out. Okay, so the devil is now in the details. And what we're talking about today is a relatively narrow but really important area within the cross-border bankruptcy discussion, which is what is the role of choice of law. Up until now, the focus has been on cooperation and comity, and the questions of applicable law have generally been pushed out of the conversation for some reasons, largely out of fear. In the sense that there was a concern that choice of law was too hard, choice of law had a territorial base, and bringing it into the conversation would undercut the universal or global goals of cross-border administration. But another sort of thread has emerged in the conversation that actually addressing choice of law has some promise. It might help limit some concerns about forum shopping and facilitate cooperation. And so the tension, so the question that's going to be on the table today is it time to address choice of law? What do we get out of it if we do it? And how procedurally might the questions best be approached? Now, let me give you 2 seconds to talk about the structure of the day, and then I'll move over there to be the moderator for the first panel, which means all I will do is introduce people and mind the clock. The way we've structured the day is in terms of 4 conceptual panels, which we may or may not, the conversation may or may not track this exactly. The first panel will introduce the state of play from an international organization perspective. Where have we been and where are we going? The second panel will talk about the role of bankruptcy law and the bankruptcy forum in coordinating a cross-border case. The third panel will talk about when and how we might allow local law to creep in. And the fourth panel, which is going to reflect a theme that's going to come up all over the course of the day, is to what extent does this help or harm, and to what extent does the widespread existence of corporate groups affect the conversation? So that's the structure of the day. We'll break for coffee and lunch at various points, and you can tell me if how we're doing. Thank you all so much for coming. Our first moderator is me, and our first speaker, who I will introduce, is Susan Blockley.
So I'm Susan Blockley. I teach at Fordham, although at the moment I'm partly in residence in London, which is what has enabled the research on this paper. Thanks very much to Brooklyn Law School, to the Journal, to Ted, to Bruce, and also to Dean Allard for making this conference a possibility. This paper looks historically at the subject of this conference, choice of law in cross-border bankruptcy cases, and it focuses on a single moment, which many of you might not have been aware of. It turns out that there were elaborate conversations in the fifth session of the Hague Conference on Private International Law in 1925 on the topic of cross-border bankruptcy. A brief roadmap of my talk suggests that it'll proceed in 5 parts and roughly chronologically. So let me proceed first to give you a little background about the Hague Conference on Private International Law. It began in 1893, really before the Hague Conference on Peace, which is probably the more famous of the Hague Conferences. The early sessions were held on an ad hoc basis, and before the fifth session, there were sessions in 1893, 1894, 1900, and 1904. These were largely, if not exclusively, European. That is, the private international law conferences. The peace conferences were much more widely attended. The UK and the US did not participate in these early Hague conferences. In fact, the US was not a member of the Hague Conference until something like 1968, and Britain until something like 1953. And these common law countries were actually concerned about participation in the Hague Conference, as well as participation in some other diplomatic conferences on the topic of the unification of private law, ostensibly because as common law countries, the government that would have signed any convention could not necessarily have committed to the adoption of the uniform rules on the topic of those conventions, because the Hague Conference on Private International Law topics were largely procedural, jurisdiction, enforcement of judgment, applicable law, and certainly in the United Kingdom and largely in the US at the time, these were topics that were subject to judicial discretion in a common law setting. So here are some. Now, this is probably the peace conference. I couldn't find on the web photos of the PIL conference, but there are pictures that it was just hard to rip them from a book and then scan them and then have them be visible here. But they do exist, and I'll figure out if the journal wants them how to get copyright permission. But you see a lot of facial hair, and that's pretty typical. So now I want to leap from 1904 to 1924 and talk about a talk given by a fellow named Leslie Bergen at the International Law Association's annual meeting, I think it was in Paris, in 1924. The ILA had actually begun work on an international bankruptcy convention in 1879, so it was one of their first projects. They had only started about 10 years before then. The ILA initial draft convention appears in full at footnote 11 in the paper, and in saying that, that suggests that it wasn't very long. Indeed, it was not. Leslie Bergen revisited the issue of international bankruptcy at the ILA's annual meeting in 1924 following World War I, because as you can imagine, the world's economic circumstances were pretty much tattered as a result of the proceeding as a result of World War I. Now, Bergen was a London solicitor who had developed an international reputation as a a solicitor involved in transnational decedents work, when people died in one place but their will was governed by some other law, or their assets were spread around Europe. And he took up the topic of international coordination of bankruptcy cases because he saw similarities between the two topics, and also because as a citizen of the world, he understood that insolvency law was important in the context of economic crisis. So he gave a speech entitled Conflict of Laws Relating to Bankruptcy and the Liquidation of Companies and the Need for a Special Tribunal. P.S. He never really got to the special tribunal part in his speech, but he obviously intended to, because that was the name of the speech. And he gave both an economic and a legal case for reform of private international law in this context. And the economic case was right up the middle of the road, pretty straightforward. He said at any time of trade depression, there's an increase in the list of failures. And of course, World War I had led not only to economic trade depression, but also in an increase in insolvencies, not only in the UK, but elsewhere. And he noticed these insolvencies were increasingly cross-border in effect, which meant to him that choice of law rules should allow for coordination of those cases, but he thought that the choice of law rules at the time worked badly and were in need of reform. So the legal case he presented began with what was understood to be the general rule of private international law at the time. And it's a rule of private international law, of choice of law, that you'll hear repeated over and over again, so we may as well get started with it. It's Latin, lex fori concursus, but all that it means is that the law of the forum state should govern, especially as relates to procedural topics, right? And while Europeans think of bankruptcy law as exclusively procedural, and so therefore that this rule of lex fori concursus should resolve the issue, Bergen begins his paper by saying, well, yeah, but abstruse questions arise as to whether provisions of substantive law end and mere procedure begins. So his legal analysis is mired in the 1914 English Bankruptcy Act, but even then the English Bankruptcy Act was very extraterritorial in its assertion of jurisdiction. Bergen says, well, yeah, you can say that in the book, but assertions of extraterritorial jurisdiction are quite dependent upon choice of law rules, and specifically the choice of law rule of lex fori concursus. So what he does is, he was obviously Talmudically trained, or a philosopher in some sense, because he's got this matrix in his head, right? And the matrix fits the globe into the matrix. So he's got, on first instance, an English trader with interests and assets abroad who becomes bankrupt in England, and then he says, okay, well, what about the English trustee in bankruptcy who wants to pursue some of those assets, and he picks France, coincidentally, as where the assets might be located. How would that English trustee in bankruptcy be received? And then talks about the complicating factors of local creditors in the local court. And so he posits these parallel proceedings opened in England and France, and hopes that there could be coordination between the two. And he says, yes, absolutely, they should. There should be coordination between the two, but it would be the English trustee in bankruptcy who would be proceeding before the French court seeking recognition, and of course the propriety of that recognition is a question of procedure, and so it would be governed by French law. The lex fori concursus, right? And he said, well, lex fori concursus, except everyone understands that dirt is governed by the lex situs, by the place where the real estate is located. Personal property at the time, private international law rules understood that the law associated with personal property should follow the law of the domicile of the owner of the personal property. But he says everyone understands that as a practical matter, physically the personal property may be located somewhere else. And then it's the lex fori concursus as to procedurally how to address the substantive law affecting the personal property. Complicated further by requests by local, and he begins with French creditors who proceed before a French court. And then he says, well, of course, English creditors who are savvy enough might hire a French attorney and appear before a French court and try to get French assets, and there's nothing necessarily that would prohibit them from doing that other than the English rule that says, hodgepodge, you can't proceed against both pots. But if there are more assets in France than in England, this is all in 1924. Very, I don't know why we're here. Why hasn't this been figured out, right? So then he goes through the idea of a French trader with interests and assets abroad who files for bankruptcy in France, and the French syndic comes to the English court, and he admits readily the rule long has been that English courts should respect the requests for recognition by foreign trustees in bankruptcy. But he says, English courts are going to read those rules of private international law, which they themselves have made, very narrowly. And he puts forward a case of In re Otoya Hermosas, which is obviously Spanish and not French, where the English court narrowly reads this private international law rule as applicable only to 2 bankruptcies, where there's a bankruptcy proceeding pending in a foreign before a foreign court, but what's happening in the local court in England is a receivership. Well, we're going to throw the private international law rule out the window. And, of course, things get even more complicated when there are local English creditors, and, well, you get the idea. So Bergen makes a speech. It's obviously a big hit because there's a resolution and draft conventions that emerge out of the ILA and the International Chamber of Commerce. Well, I wouldn't be too impressed because he was kind of president of both. So, but in any event, the British Board of, or the English Board of Trade, I don't know, British, English, the Board of Trade at the time, His Majesty's Board of Trade at the time, was also bombarded by letters from Bergen about the necessity for participation in the Hague Conference. Remember, Britain has not been involved. So S.W. Hood, the Inspector General, this is a PDF of a photo of the folder that I had, was able to recover from the British National Archives in the Kew Gardens. So Hood is bombarded by requests for participation at the Hague Conference, and he's a good bureaucrat. He solicits information from the trustees over whom he has jurisdiction at the time, and he asks them, what are your experiences? Are you recognized? Would you recognize foreign trustees? And there are a number of reports from trustees that appear in the records. Hood appoints an informal committee. They meet over the summer and decide that, well, Great Britain can't be party to a general treaty on the topic, but we could agree to a convention that recognizes, when there are parallel proceedings, having the trustee in one country recognized in the other. So on that basis, they proceed to The Hague, at The Hague, they find delegations from 22 European countries, including for the first time Great Britain. Bankruptcy was not the only topic on the agenda, but it was the first topic, and the delegates began with a draft convention that had been left undone in 1904. The records of these proceedings are extremely complete, but they're all in French, and the books are hard to find. But okay, putting all of that aside, they provide statements first from one delegation and then another. And so the British delegation, we can tell, spoke very little, but he did intervene several times, purportedly in French. But on the 4th day, the British delegation entered into the records of the proceedings a statement which, unlike anything else in the proceedings, is entirely in English, so I can read that. And the statement closely resembles the informal committee's recommendations to the Board of Trade. That is, that Britain could only envision a system in which the bankruptcy of a debtor in one country would be in itself ground for declaring him bankrupt in the other, and that where such a course did not appear to involve practical inconveniences, the trustee in the first country should be trustee in the second. But that's it. That's all that they could envision. And it appears as though the British delegation left, having thrown this bomb into the proceedings. The following day, the German and the Spanish delegations introduced their own statements, in French into the records of proceedings. And both support, and here I'm quoting, although translating, but it's pretty obvious what it says, both support the grand principle of the unity and universality of bankruptcy. Now, the German delegation backs a little bit away from this, saying, well, it's not an ideal that would be realized easily, but he only mentions two possible exceptions. And these are photos of the books of the proceedings. After the final day of the proceedings, the chair introduces a report which admits that the revised draft doesn't follow principles of unity and universality with absolute logic. Nonetheless, he characterizes the convention as predominantly universal, and I would agree with him. There are probably a lot of things to be said about this historical account, which we can talk about further during the day, but essentially what we have here is a picture of the emergence of a comprehension of the importance of cross-border insolvency cooperation, legally and economically. There is tension between the economic interests and the technical legal analysis that's ongoing, and indeed we have a British delegation which presents a position that's too pragmatic for the room filled with idealists who are otherwise panicking in the room. There is, throughout these deliberations, a murky line between procedure and substance, and there is also, surprisingly, an absence of private international law rules in this draft convention at the Hague Conference on Private International Law, which I think is because there are enormous trade-offs between procedural and substantive rules in this area, as well as the murkiness of the distinction between the two.
Thank you, Susan, for demonstrating the even longer history of this area than any of us had possibly imagined, and the consistency of the issues that arise, if not the positions of the players. The next, I should also, by the way, add that we left Susan off the list of people who've been at this conference twice. So that's because she's my doppelganger, and I figure anyway. So for our next speaker, Jenny Clift from the Secretariat of UNCITRAL will bring us up to speed on where things are now.
Thank you, Ted, and thank you to everybody for inviting me to participate at this symposium. I wish I'd read Susan's paper, or actually I wish she'd written it 10 years ago when I started doing this insolvency work, because then I would have realised that we're going around the same circle for, second, third? I don't know what happened between 1924 and 1997, but I don't know. Anyway. And I have to say that when I started reading again, because I've read them several times, but reading back through the UNCITRAL papers for the model law, it's kind of going around the circle. So the issues keep arising, and we keep finding different ways of resolving them without actually having to deal with the choice of law issues head on, I think. It's probably useful if you don't know anything about UNCITRAL, if you read Chris Redmond's paper. He should actually be going first probably, but because it's a really good, it gives you a really good idea of what UNCITRAL is and how it actually operates, particularly in the insolvency field. Essentially, we have a mandate for harmonisation of international trade law, and in order to give effect to that mandate in the insolvency field, we have elaborated a number of different texts that have the goal of harmonising, well, not so much substantive insolvency law, that came later. We started out looking at cross-border insolvency law, but the general idea is to minimise the impact of conflicts that arise from the differences between insolvency laws. Firstly, if you harmonise the law, and we don't necessarily distinguish particularly clearly between procedural and substantive in that regard. And then secondly, promoting cooperation and coordination in cross-border insolvency proceedings. And within those texts, there's a relatively limited treatment of choice of law rules. But we have done, well, depending on which commentator you read, some people say we've done something that's murky, some people will say we haven't touched it with a 10-foot barge pole. I don't know. You have to decide for yourself on that, but we have done something. What I wanted to look at in this paper was really to see what the relationship between harmonisation of law and choice of law issues is. If you're harmonising law, do you actually have to deal with choice of law issues? Or is choice of law a totally separate project for harmonisation itself? So within the things that we've looked at in insolvency, we haven't really dealt with choice of law rules. And now it's being proposed that we look at choice of law rules as a separate topic. Harmonisation itself is an interesting issue, and there's lots of different views about whether it's worthwhile or it's not worthwhile. For better or worse, that's essentially what I've spent the last 14 years of my life doing. So I guess I have to come down on the side of if it's something that's actually worth doing. The idea is generally that we facilitate international trade by reducing jurisdictional differences, facilitating cooperation and coordination through a common approach, improving efficiency and predictability of transactions, and enhancing the transparency of the law by adherence to a common standard. And I think from the harmonisation perspective, you would have to say that the texts completed by UNCITRAL in the international insolvency field have, to a greater or larger extent, achieved some of those goals. But clearly, and particularly in the insolvency field, there are fairly entrenched obstacles to harmonisation because of the very nature of insolvency law itself, I think, although perhaps it does apply to other areas of law, that it does reflect a number of choices that states make about social, political, financial and other considerations that impact the economic and legal goals of insolvency proceedings. So it's a fairly complex mix. And for those reasons, it's perhaps not all that surprising that choice of law in insolvency hasn't been confronted head on. It's not to suggest that we haven't spoken about it, that it hasn't been raised, that it hasn't been proposed as a topic for possible future work, because it has. But per se, it hasn't been accorded a high priority in our work on insolvency law. Historically, we've progressed in the insolvency agenda by, to some extent, putting aside those issues that are more difficult, highly technical or controversial, sometimes with the intention of coming back to them at a later time. And one of the more recent examples of that is when we were doing the legislative guide on insolvency law, was that of corporate groups. And we thought, well, we can either try and tackle it within the legislative guide project that we had going at that time, or perhaps not, maybe it'll take too much time. I think in retrospect that was probably the best approach, because we might still have been there trying to do the legislative guide. And for anybody, I don't have a copy, I don't have a visual aid, but it's a fairly thick text anyway. So to try and... I think the temptation with insolvency law is you can see that you could just keep on going on, and people say, but it doesn't deal with this and it doesn't deal with that. But had it would have been about this long, not this thick. But the postponement, I don't think, should be seen as a bad idea, because what does tend to happen is that as people start talking about the issues, you get a more gradual approach, or a gradual move towards something that will be successful. If you confront it head on, you'll often find that it's just, the dynamics of the working group make it really hard to advance forward, and you can see the distress in the room, and the discussion goes round and round in circles, and nobody can really find a way to get out of that circle. So if you come back to it at a later point, and you've had time to think about it, time to prepare, time to maybe have some expert group meetings, have symposiums like this, you can perhaps find a way forward. If you can't, then obviously you don't go there. Maybe choice of law fits into that category. I didn't say that. The first text I was going to briefly look at was the Model Law on Cross-Border Insolvency. That was adopted by the Commission in 1997. And the idea of it is to provide a framework for cooperation between jurisdictions to facilitate and promote a uniform approach to cross-border insolvency. And as such, it describes itself as limiting its scope to procedural aspects of cross-border insolvency cases. The text was arrived at by having a series of studies and consultations that started in 1993. And the consensus that emerged from that work pointed to having something with a very limited scope. All the discussions are very much couched in terms of limiting whatever it is that we're going to do. Establish a number of basic principles, threshold rules that would facilitate efficiency and speed in responding to cross-border insolvency cases. And they came up with 4 areas: access, recognition, again, that idea of recognition, providing relief to recognise proceedings, and once again, cooperation and coordination. There were a number of conflicts issues that were raised in the context of the discussion, such as what sorts of proceedings should be covered by the rules, whether we should deal with priority rules in distribution of assets, recognition and treatment of security interests, avoidance of debtors' transactions that were prejudicial to creditors, and the law applicable to ancillary proceedings. But the working group, having looked at those, having raised those issues, the working group noted that there were various national law reform efforts underway that were focusing as a basis for assistance on something other than comity or mere rules of private international law. Those efforts that were suggested, which typically involved establishing mechanisms for granting court access to representatives of foreign insolvency proceedings and otherwise recognising foreign proceedings, might serve as an indication of what might be feasible in terms of international harmonisation. And so the conflicts approach was put to one side. And I think when you look at how the dynamics of the discussion evolved, you can see this approach of trying to find another way of doing things. So, for example, if you look at the key element of recognition and what should be the effects of recognition. And there were various approaches discussed. One was to have an exhaustive enumeration of the effects of recognition, and a second involved a reference to applicable law. The second had 3 possible variations. The recognising court would determine the effects in accordance with domestic law. They would be determined in accordance with the law of the commencing jurisdiction, or in accordance with either of those 2 laws. And the discussion looked at the various pros and cons of each of those approaches, but ultimately decided that the model law itself should specify what the effects of recognition should be. So you should have a minimum list of measures that would be triggered by recognition, centring on the need to quickly protect assets against dissipation and allow time for a comprehensive assessment of the situation. Leaving discretion for the recognising court to provide additional effects if appropriate. And that approach was viewed as accomplishing the fundamental purpose of the project, that is, introducing basic enabling legislative provisions, creating the capacity for judicial cooperation and recognition of foreign insolvency proceedings. And it kind of bypassed the need to actually decide whether you needed to look at the law of the receiving state or the law of the commencing state for determining effects. And the same approach was adopted with respect, for example, to some other elements. They talked about how you define a foreign proceeding. And one suggestion was to create a presumption that the proceeding had been properly opened in the commencing state, which meant that you would then have to go and look at what the law of the commencing state was and make a decision as to whether it had been complied with. There was also a suggestion that there should be a substantial connection between the debtor and the commencing state. Both of those were felt to create uncertainty, and so they were later deleted. And essentially, the foreign proceeding that's recognised is one that meets the criteria specified in the model law. And you can see that approach also with respect to what the qualifications of the foreign representative were to be, and other elements. So much for the model law. We then move on to the legislative guide on insolvency law, which was negotiated between 2000 and 2004. And in that instance, it wasn't included within the matrix of subjects that were initially to be included within the legislative guide. We started drafting in 2000, and by 2003, or in 2003, people started suggesting, well, maybe we should start thinking about whether we can include something on conflicts. And I think the dynamic of it was, when we started out, there was great scepticism as to whether, in fact, you could produce a legislative guide that would deal with substantive insolvency law issues. And the conflicts of law was probably just, I don't know, you'd have to ask people in the room. Maybe it was just something that was too far at the time. It's kind of difficult to find out what the dynamics in the room. As a member of the Secretariat, I'm kind of, what's the word? Distant in a sense from, I'm there in the room, I hear what everybody says formally, but I'm not party to any of the other informal discussions. And so it was a great surprise to me when somebody came up to me at the end of when we finally got the legislative guide done, and they said, well, you know, up until today I never thought we were going to do this. And I'd been blithely going along thinking. So there's a lot of dynamic in the room about, you know, what's happening that I'm unfortunately not privy to. But so the idea was, in 2003 we should try and include something on conflicts if we could. We spent 2003 having a couple of expert group meetings involving the Hague Conference on Private International Law, and coming up with a fairly, I won't say simple, but it was, in the end, it was actually fairly simple to achieve the provision on lex fora concursus being the governing most of the aspects of insolvency proceedings, with a couple of exceptions for labour contracts and financial markets. And when it was finally discussed, it wasn't one of those horrible discussions that I think people had envisaged. Most people agreed with what was there. There was a bit of movement, a bit of redrafting, and a few items were placed outside the choice of law chapter, but by and large, it wasn't as difficult as we thought it was going to be. So I guess my conclusion is that it probably is a difficult area. It isn't necessarily one, I think, that we have to address in order to harmonise. I don't think that the model law should be seen as failing to address the issue, because I don't think you can fail to do it unless you actually set out to do it, and I don't think we did set out to do it. It's gone about its work in a different way, maybe in the context of the work that we will be beginning to look at, and that is enterprise groups again. There will be some scope for looking at choice of law provisions, but just how that will play out, I'm not entirely certain. Thank you.
Thank you. For those of you who are not in the room and have not watched a Working Group 5 meeting, I don't know that you fully appreciate the role that Jenny has played in doing, and I was not involved in the process of drafting the legislative guide, but I was a legislative guide skeptic for a very long time. The fact that the thing exists and contributes to the debate is an extraordinary accomplishment, and so I think it is important, and that is in large measure due to judgment in deciding which bites to take at what time. So that is so with that small editorial, let me introduce Bob Wessels, who's going to speak, I think, principally from a EU perspective about the things that are developing on the choice of law front. Bob Wessels is a professor at the University of Leiden and a person who has forgotten more about cross-border insolvency than I will ever know. Bob? Oh no, I'm sorry. Well, yeah, no. Chris is going to wrap up. Right. Chris, so you're up. Okay. You're up. Sorry.
I was still preparing.
Oh.
Nou, hartelijk dank voor de uitnodiging om hier te komen spreken over... Is there something wrong?
No, Dutch is easy.
So welcome to the international world, where everyone bows for English. And I'm going to talk about what in EU lingo is called an undertaking. In my Dutch, someone who is an undertaker gives voice to
English too.
graveyards. And the same is for John, I learned yesterday. And in The Economist of last week, there's a review on a book called The Undertaking by Audrey McGee. It will be published here in September. And it is about undertaking a literal transaction of the German Unternehmen, which means a military operation. So before the EU starts to introduce an undertaking, we have to make sure what we are talking about. Let's see. Okay. So this is Europe. The Europe of the entering into force of the EU insolvency regulation in 2002 had about, was it 12 or 15 member states? Now we are 27. At that time, when the text of the regulation came into being, about 90% of the EU member states only had bankruptcy liquidation. England had something like reorganization. So we were very, at that time, liquidation focused. You have to keep that in mind. You have to keep that in mind also that at that time, groups of companies were hardly there apart from Shell and Philips and so on, but it was not so common as it is now. As I said, now it's 27 countries. Article 46 of the regulation says, well, if it's 10 years into force, we need some reports to try to amend the regulation. So there came a proposal of December 2012 to amend the regulation with 51 amendments. It includes a report on the application. It's called the Heidelberg-Vienna report, where you have national report from countries adding up to some 400 pages saying we have difficulties with this, we have difficulties with that, and then in the report it says we suggest the following changes for the existing text of the regulation. Then there is an impact assessment, meaning the policy goals of 2002, are they reached? Which is another way of looking at it. The draft report from the European Parliament came roughly a year later, in December, and when I was trying to write in my English, and I hope Lauren and her team will also revise the way I write my Euro English, in February of this year, the final text was approved. And it has, again, what I call drastic suggestions from the European Parliament saying we have to deal with certain issues differently. And I will deal with only one issue out of the 51 or 68 that are there, which is the undertaking. In the present text, which is not underlined, it says in Article 18 that the liquidator, which is the general name for an administrator, curator, a syndic, whatever his name is, the liquidator appointed by a court which has jurisdiction based on Article 3, so where COMI is, in the main proceeding, he may exercise all the powers conferred by him when he has dealings in other countries, subject to certain articles. But new is, which is proposed now, he may also give the undertaking that the distribution and priority rights which local creditors would have had if secondary proceedings had been opened will be respected in the main proceedings. And such an undertaking shall be subject to form requirement, etc. So now we have let's take a Dutch liquidator in the main proceeding. And there's an insolvency of a building and construction company building sports stadiums. And we have operations in Poland, and we have operations in France. Meaning that in Poland and in France there is an establishment. An establishment is the basis for opening secondary proceedings in those countries. But I don't want them to open secondary proceedings. I find a Chinese investor and I want to sell the whole business, including the sports stadium in those countries, to him. I don't want to sell a main proceeding and two secondary proceedings. So I'm going to Poland and I'm going to ask them, probably in Polish or in Dutch, that's the main proceeding. And the main proceeding says universal application of the lex concursus, meaning the law of the country where the proceedings have been opened, which is Holland. So my law applies also, finally, in Poland and in France. So there's an issue about language. Probably I should do it in English and Polish. And I don't want them to start secondary proceedings. Well, that is the as-if undertaking. An undertaking as if secondary proceedings would have started. I don't know the moment that those proceedings would have started, what rights would have been, in May or in September or in January next year. So it's rather vague. So here's my undertaking to you. Okay, thank you. The as-if undertaking. What's the legal nature of such an undertaking? Is it an offer that creditors can accept in the way you can negotiate a contract and as a result you have a contract? Or is it, in certain matters, something with a public nature which you cannot address with private international law rules regarding to contracts? In certain countries, the administrator will not be only representing the creditors or only representing debtors. He represents the greater good of good administration of an insolvency proceeding, which is probably a general or public interest. So, let's say that you are the local creditors in France and in Poland. How do I know? Because you live in London, but presently are in Poland. Are you included, yes or no? I'm not sure. We don't have a definition for local. There are definitions for if I have to inform creditors when opening up a proceeding in the Netherlands, I have to inform known creditors with the residence or their company registration within Europe. So not to a Japanese creditor, but also to those people who have their registration or habitual residence or domicile within Europe. So there's a distinction we have to make. Who are those local creditors and on what moment are they local creditors? Are they on the moment of May 1 when no one was thinking about opening secondary proceedings, or September 1 when it went down already in France too, and there would have been 73 creditors. Okay, given the name, the list of the creditors. If you have been in practice, you get a list of 40 creditors, and there are 23 that are forgotten, fraudulent, or just unknown. What is the content of such an undertaking? Look. Thank you. According to the European Parliament, the contents of the undertaking, and also according to the European Commission, is that the distribution and priority right which local creditors, I don't know who, would have had if secondary proceedings had been opened. Well, yesterday I was talking to Professor Mooney, and he was trying to guide me through New York, which finally we got to our target. And he was talking about preferential rights. Geez, I was 12 hours in a plane. Finally, I'm in Brooklyn. I'm for the 50th time in New York, but for the first time in Brooklyn. And he's talking about preferential rights. And I don't know what it is. Probably we call it avoidance actions or actio poliana. preferential claims for employees that have certain, what you probably call priority claims. So, thank you to the world, welcome to the world of terms. So I have to deal with what is distribution to priority rights. I don't know, for local creditors, I don't know who they are. So that's the contents of the as-if undertaking. And then, if secondary proceedings have been opened, and they will be respected in my Dutch proceeding. Okay, thank you. Now there are Dutch creditors, they're saying, well, that lady, she lives in London, but was successful in having their local rights, and you pay her 80, and you pay me 30, I'm going to sue her. She gets more than I get. It's the imputation rule or the Hodgepodge rule, whatever rule, she gets more than I get. So I can say to you, I will respect your rights, but does it exclude also the rights of third parties for tort or whatever liability? So if you have a rule like that, you have to take into Article 20 also an exclusion that this will not be void, I think the word is, when you do such a thing. The minimum criteria of an as-if undertaking. The European Parliament says, an undertaking shall specify the factual assumptions upon which it is based, in particular with respect to the distribution of local claims over the priority. To take off my glasses. And ranking system under the law governing the secondary proceedings, the value of the distributable assets within the secondary proceedings, the options available to realize such value, the proportion of creditors in the main proceedings participating in the secondary proceedings, and the cost that would have been incurred by the opening of secondary proceedings. Thank you very much, European Parliament. This is an apple and a bite you try to compare. You don't know at what moment the value, after valuation, this is terrible. I think it's much better, as we discussed in Brussels, to keep a more open rule and put those words into one of the recitals. Should there be a no worse off part in the undertaking? I'm promising you I'm going to pay you 70, but at least you will get equal or more than if you would have had if there was a liquidation of the whole lot. I think it's worthwhile to take such a no worse off rule within such an undertaking. Now I'm Dutch. So I've got 80 in my pocket, and I say to Professor Hollis, I've done my utmost, but I'm going to undertake you 55, which is Dutch. And he said, well, fine. And you said, no, I want to have more. He's German. Oh, 65, 70. Can we negotiate? Should an undertaking be an all-in-once effort? Or can I have, is it horse trading?
Horse trading.
What I call cow trading, which is Dutch.
In Brooklyn, it's called handling.
So my idea would be you should prevent horse trading, and it must be a one undertaking. No conditions. Well, I'm giving my undertaking to you under the conditions that the guys in Poland also accept the undertaking. I think that's a natural condition within such an undertaking. But it is not clear whether it is allowed to do that. Can I take into condition that 80% of all the creditors in those two countries accept it, or 70%? And if so, what do I do with the holdout creditors, or the creditors that say, we don't want to respond to his email. We don't want to be seen as accepting tacitly that undertaking. Well, within the ALI, III global principles, Ian Fletcher and I think it's at 36 and 37, we gave some rules or some principles trying to reach that indeed you cannot hold out, but you are bound at that time. Form requirements for the as-if undertaking. Fine, the European Parliament, all representing their own nations, and said, well, every national state should have its own form requirements. So you have French form, Italian, Estonian, okay, welcome. I don't think it's wise. I don't think it is logical, but an undertaking, as I said in Article 18, the first part of Article 18 is giving a wider implication of my national powers. But the undertaking given here is a union power. It's unrelated to my national law. It's coming from the union. So it should be union type of form rules for it. And then in the end, because I think it's 29, yes, the European Parliament, they distrust not only the Dutch main liquidator, as we call them, but every main liquidator. Because it says in the European Parliament proposal, the court referred to in paragraph blah blah blah, may appoint a trustee whose powers are restricted, which is indeed not being the secondary country. May appoint a power. The trustee shall ensure that the undertaking is duly performed and shall participate in its implementation if this is necessary for the protection of the interest of local creditors. The trustee shall have the right to petition in accordance with Article such and so. So this is the mistrusted trustee, or he's there as an agent to supervise what the main liquidator is doing. There's no Annex D in the regulation, so it can be anyone. We hardly know what his task is, so I don't think it is worthwhile to go that route, because if you are in practice, which I've done a very long time, you go to Poland and you say to a Polish local lawyer or a French local lawyer, please guys, assist me with all those nitty-gritty in your country. Well, having said this is an undertaking, then we come to applicable law. So my first question is, what rules will apply? If it is contractual, you probably say the principle of autonomy, being that I decide what law will be on that undertaking, and that the Polish and the French creditors, whoever they are, say, we are more comfortable with French law. Then I say, fine, but it is Dutch law, apart from being whether it's good or not. So we start to go into negotiation of what law applies. Or has it this general principle element of being an undertaking, trying to avoid secondary proceedings, which basically influence the model of the EU regulation, and therefore it would be normal that the lex concursus would apply, which then is Dutch law. But Dutch law says that we will treat you according to your French rights. So that's one thing. Second, can I make a split choice? I'm giving an undertaking to the Polish guys and to the French local creditors. Probably not doing that in one undertaking, because then you have the rule of dépeçage, meaning you have a split of applicable law in your contract. And I hate those clauses. So probably you have a unilateral sort of promise to one country and a unilateral promise to another country. But they must be connected, because if the French say, mais non, then I don't want to keep my undertaking against the Polish. The next one would be, can I take into my undertaking certain clauses? I think the first one is, if I approach one country, the other country also has to agree on the same terms. Secondly, if you're in international commercial contracts, you go into your boilerplate and you say, shall I include arbitration? I think we should include arbitration in such a case and not go to local courts. Can we include a Versteigerungsklaus? You know what it is? A clause saying, this is the undertaking according to the law at the moment that I give the undertaking. Any changes later will not have influence on the undertaking. I think there should be a Versteigerungsklaus, or I don't know the English word for it. Now there's no choice of law. What law will apply? That's my final remark. I can go on till 12, but tonight.
You'll get to talk more.
My final remark is, now we've got this main liquidator from the Netherlands. This is his first international case, which is not unique. So you know, I can make what's the word undertaking? I don't know what it is. But, so he reads my books or your book, and he finally knows what it is, but he forgets to pick a choice. What law will apply? According to the Rome I regulation in Europe, which applies since 2 or 3 years, the contract, if it is a contract, shall be governed by the law of the country where the party required to effect the characteristic performance of the contract has its habitual residence. The characteristic performance. What's the characteristic performance? Me giving an undertaking? I think it's much more important in practice that you accept it. So it will be Polish or French law? Or does it look at when I finally pay you, and then it's again Dutch law, because that's the characteristic performance, unless I have an account in Sweden and I pay you out of Sweden, then probably Swedish law is applied. So there are still some questions to discuss on this matter. Thank you very much.
Thank you, Bob. And now for those of you who haven't been in a room when a civil lawyer talks to a common lawyer, now you see what happens.
What does mean?
Yeah, right. And also perhaps that procedurally going forward, the EU reg approach might not be the smallest bite to take out of the apple. Chris Redman, who's had many roles as a lawyer in this process, serves currently as the member of the U.S. delegation to UNCITRAL, and once you hear what he has to say, you'll understand that he understands better than anybody that I've seen the pragmatic way in which this process moves forward.
Good morning. Thank you very much. It's a pleasure to be here. As an attorney in private practice, I have to reach results for clients. And so what I want to try to focus on is taking this concept of choice of law and illustrate how this would work at UNCITRAL in trying to reach a result. Because the ultimate determination, the ultimate issue is taking a theoretical concept, going through a lot of debate, a lot of discussion, and getting to a result, but making that effective. As Professor Vessels has related, the European Union is doing that through the European regulations and the revisions to it. UNCITRAL has done that through different works that's been promulgated. Jenny has already talked about the model law on cross-border insolvency, and she's also talked about the legislative guide. The legislative guide has actually been recognized by both the World Bank and the IMF as an international standard on insolvency reform. And so there's many, as part of that, it goes along with the World Bank principles for ROS, for country assessments, to determine whether a law in a country is sufficient or not. In addition, UNCITRAL has developed, and you have to remember that UNCITRAL Work Group 5 didn't start until 1993. The model law was developed and completed in 1997. Legislative guide was finished in 2004. Also, UNCITRAL has developed a treatment of enterprise groups in insolvency. Has also completed a director's obligation in the period approaching insolvency, has completed Judicial Perspective, which is a book for judges and counsel that details the integration of the process of all the UNCITRAL products, and also they developed a practice guide on cross-border insolvency cooperation, which is basically a book on protocols, how to utilize protocols. This has all been done and accomplished since 1993 in a very short period of time. Now, what's important to understand is how the process works, because that's a critical, I think, aspect to understand how to move this whole concept and this whole idea forward. UNCITRAL is a member of it's one of the bodies of the United Nations. There are 60 member states that are permanent members of UNCITRAL, but also observer states participate, and often we'll have 20 or 25 observer states appear. There's also NGOs that the Secretary determines which NGOs are appropriate to invite that can provide expertise. INSOL, American Bar Association, International Bar, IBA, III, a number of organizations that provide specific expertise. Now, the important issue is that when these issues are addressed on the floor, again, you have people from every continent, you have different legal cultures, you have different political environments, and in order to arrive at a product and a decision, we have to have consensus. That means everybody basically has to agree on the product. Can you imagine if we were trying to process this for the United States Congress today, trying to get agreement? But as much diversity as there is, the Working Group 5 works very well together. A lot of the people have been there a long time, have been there since the model law. And Professor Younger said earlier, Jenny Clift is owed a great deal of gratitude by the international community because of the work that she has performed. She guards the system. As you can imagine, there's a lot of discussion, a lot of debate, a lot of political policy issues that take place. And once we reach consensus, Jenny is the keeper and the guardian of that concept, and so she'll adopt that in the papers, but then the issues that we haven't agreed upon then go into the next paper so that we can go back and try to go through this entire process all over again. Now, I want to give you a couple examples just so you can put this in perspective. When we started working on the legislative guide, there was a great amount of discussion about different systems around the world, different countries, different states, laws as part of the process. And one of the issues that came out very early was the Europeans took the position that we have to respect contract rights. We can't abrogate those. And the second issue was that in Europe, secured creditors defined what a debtor had as property estate by what was left after the bank liquidated the property. And in many of those situations, there was liquidation. And so those are two fundamental concepts in order to develop a modern system that were very difficult to resolve. It took us 2 years until we arrived at the concept and agreement on the automatic stay, which allowed debtor time to breathing room to try to restructure. And also, one of the most difficult realizations we were able to determine was property estate. As to what was part of that property, there was a number of jurisdictions that said it's only a residual part, but we were able to get a broad definition. And what emerged from that process was that the states came to the conclusion that reorganization was much more beneficial to companies than liquidation. And so we need to establish a procedure and a structure of how we reorganize. And that's why the automatic stay was approved. That's why property estate was approved. And then all the different structures that came in place helped to move that along. Now, what's also important is the makeup of UNCITRAL. States have, each delegation can have who they want. And a number of delegations will bring individuals who are experts, very knowledgeable. Other delegations will bring their missions. And the mission is there for all the different sessions, all different areas, really has no expertise. And in the legislative guide, one of the issues that was very beneficial is we had one delegate who was there by himself, was not an expert, would go through, would talk about issues, and he'd put his flag up. And he said, can somebody please explain to me what you're all talking about? Because I have absolutely no idea what you're talking about and what your position is. And the reason that was so important is that Working Group 5 has tried to develop text that are understandable. And if people that are in the room can't understand those, it's critical to get it to a position so it is understandable. And the working methods that is also important to make sure that it gets detailed. The working group in UNCITRAL, when a project starts, they start at the base. What are the different aspects here? Let's talk about this in plain English. Let's get the basic building blocks understood before we go to step 2 and step 3 and step 4. And it's like the old issue, you can lead a horse to water, but you can't make him drink. And so sometimes the working group gets to a certain point, and they're not willing to go past that. And a lot of the issues of why that occurs is that people want to reflect. Because when you have this number of states, this number of NGOs, these documents are really well vetted. All the different states take instructions. There's many policy determinations. Part of the key is that these are forward-looking documents. These are documents not only for now, but they're intended to address issues into the future. And you want to try to address all the different factors that come up. You don't want to miss critical issues. And so as a result, there's a lot of discussion. There's time being taken to make sure these work properly. And just to put the issue of choice of law into perspective, UNCITRAL just finished a revised guide to enactment and interpretation of the model law. That was just published very recently. It was approved by the Commission in July of 2013 in Vienna. The U.S. delegation, as one of the final discussions on that work, made a suggestion, saying, why don't we incorporate in this work a basic statement that the location of Comey should be the principal jurisdiction that law control in the overall proceeding, not a complex issue. We had so many delegations intervene, saying there's so many exceptions that if we try to address this and we try to focus on this, because of all the policy issues, because of all the exceptions, it's going to take another year. And so we withdrew our suggestion. So all I'm saying is this is a very challenging area. It's a complex area. There's policy issues that need to be decided as part of this, but there needs to be basic building blocks. And so this process needs to be carefully addressed, and I believe will be addressed as part of the group enterprise, because one of the issues the working group has elected to go forward on is to address insolvency in a group enterprise basis, whereas the model law is a single company and addressed on that, we're now going to be addressing multiple companies, subsidiaries, et cetera, as part of the group. So this is a time, I believe, but it's an issue that has to be carefully addressed, and the policy decisions need to be carefully considered, because again, once UNCITRAL completes the work and countries adopt this as a model law or as part of their legislative guide, or the European Union adopts this, or the World Bank or the IMF takes it on, this is going to be an important aspect, because this will control and dictate the course of many cross-border insolvency proceedings. Thank you.
So this is remarkable. We've finished all the presentations with time for discussion. Ordinarily, I would ask the first question, but I'm not going to. I'm going to clarify one thing and then open it up and get the room discussing as quickly as possible. There's one thing that both Chris and Jenny alluded to as a procedural matter that I think it's probably useful to clarify for the purposes of discussion going forward, which is where choice of law exists within the current mandate versus future work projects at UNCITRAL. There are two different things that are viewed as on the table and things that are viewed as might be taken up in the future. And at the meeting in Vienna, the concept of the synthetic secondary or as-if distribution was introduced as something to deal with in current work with regard to corporate groups and the officers and directors liability. And that's one piece of the project that we're talking about today. And Bob's presentation pointed out how difficult even that may turn out to be. But then there's a second project which was identified as a matter for future work, which I think is something that we ought to talk about, but is really for the long term, which is an effort to actually harmonize choice of law rules for cross-border cases and for cases and for locating assets and claims. So I just want to sort of make sure that we've got those two concepts or ways of talking about the choice of law inquiry distinct in our heads going forward. With that, would anyone, we'll start around the table, anyone around the table have a question or a statement or a thought?
Can I make a statement?
Oh, yeah, sure. Oh, I'm sorry, the panelists, yeah, go ahead. No, that's panelists first.
Well, I retired last week, so maybe that's the prerogative to start first. Just as, because it comes forward as rather abstract, a legislative guide and so on, there's written evidence that the guide has been used in new legislation in Austria in 2009 and in France. And there is anecdotal evidence that it is used in Belgium for the Act on the Continuity and in the Netherlands when we were thinking about the concept of introducing what the Americans call a stay. I mean, in our commission, we said, well, in our law, we already have what we call a cooling off period. Is that the same as a stay, yes or no? Can we have pros and cons for using a stay? Should it be automatic or on request? And all those questions are in the legislative guide, and that polishes and aligns the thinking in a group of 12 with different interests to try to amend their own rules. So it is a tremendous instrument. So whenever you from America go to another country, you can introduce it with some trust. That's my statement.
Any other comments on the panel? Don, Henry?
I'm not sure whether this is a comment or a question. I'm not sure whether this is a comment or a question, but I want to start out by saying that these 4 papers were extremely valuable because they pose the question of whether it's premature or not to deal with conflicts of law, and they do it in a very, very good way from different perspectives. The question I have is, we have been living for the last 25 years since the Maxwell case with an ad hoc approach to all of these issues, case by case. We were fortunate in the Maxwell case to have 2 judges who figured out how to get along with each other, and a couple of parties in the cases, including the examiner and the administrators, who worked out a protocol. And because of that, that became the template, I think, for what UNCITRAL did, which was to encourage that sort of cooperation. And we are now beginning to see, first of all, that effort has been very valuable. It has actually helped us manage our cases for the last 20 years, or since it's been in effect in different countries, maybe 10. But what is beginning to surface now is impediments to getting cases done, because I think we are seeing more parochialism country by country, and that includes the United States. Just as an example of something I think should have been an easy case, there was a sale of assets that was approved in the main proceeding in a Japanese case. And in the United States, rather than simply saying the main proceedings rule governed in the Chapter 15 case, we said, no, we're going to review it de novo. I think that kind of impulse is increasing. And so do we need to have more guidance? And I'm asking all the panelists, do we need to have more guidance on conflicts of laws because the old ad hoc approach isn't working?
I think as UNCITRAL addresses this in group enterprises, the procedure UNCITRAL has utilized, and legislative guide is a good example. It talks about initially what's the problem. It talks about each subject matter area of insolvency law. And it talks about what's the problem. What issues are there? And then it talks about here are some alternatives. Here are different ways to approach it. And then it goes to recommendations. It says, and the recommendations again are only in the guide on the basis of consensus. If there's not consensus, there's not recommendations. And I think the issue we're now facing again is education. I know I'm not going to talk on behalf of the State Department, but I know there's concerns because of the lack of recognition in some of the cases and the lack of trying to follow through what the model law was intended to do as part of the process. We've seen in many of these cases, especially in the last 5 to 7 years, much more litigation, much more, and to the extent that UNCITRAL operates on the basis of economic determination. I mean, Jenny can comment on this too, but during my time period there's very, very few times I've seen states take political positions. It's mainly economic, saying, what is the benefit? And that's why UNCITRAL can agree. That's why consensus occurs, because once you demonstrate economic issues and what's beneficial, that's understood. I think several years ago, the Europeans at the start of one of our sessions took the floor, and they said, we've cooperated, we've worked together, but there's severe economic issues, and so we need to speed up what we're doing. We need to address these quicker to try to get resolutions out there as part of the process. And that's part of the challenge. And I think papers like this and these symposiums help lay these kind of issues out, and it's important as problems occur to get those identified so they can then be addressed. But I think they do need to be addressed.
So I have Irit and then Chuck. Irit?
Can I actually
Oh yeah, sure.
separately?
No, sure. I'm sorry.
So Don, part of what I'm hearing you ask is whether the UNCITRAL process could rein in U.S. courts of appeal. Okay, so because it seems to me that it's worth emphasizing that the legislative guide, the model law, these are all soft laws which may set international standards, but we were extremely lucky to have the model law adopted statutorily by the U.S. Congress. Whether this Congress or a future Congress would revise that law in some way, I think I'm really dubious about it. That said, education, I agree, is very much the project, and I do think that courts generally, not just limited to U.S. courts, but courts generally who have territorial mindset increasingly, perhaps because of the financial crisis or perhaps for other reasons, are educable, and that's why projects like this, conferences, as well as soft law emerging from international organizations, is so useful, more for its educative purposes.
I'm going to interject one more, which is, actually, I heard Don to be asking something a little bit different, and then he can tell me if I got the question right, which is, there's a sense when we talk about choice of law that we're retreating to the old territorial and divisive old days. And I heard what Don was asking was, is there a role for an understanding about choice of law in actually encouraging cooperation?
That is one part of my question, and I agree with Susan that this is a multi-year project, and it also, when I say multi-year, maybe multi-decade, and it also requires some more convergence in the substantive insolvency laws of different countries, but that is happening slowly over time. First of all, I do think that soft law can influence judicial behavior. I also think that soft law ultimately makes its way into legislation. The way Keynes said, philosophers and economists affect the world in the future as well. So I think that we have to start talking about these issues, because each case now we're running up against impediments to value maximization and the counterbalance of fairness. And we need to think about those 2 points in determining what our choice of law rules should look like. And once we know that, even if the legislation is years away, we can begin to articulate a rationale.
So, Irit, we'll move one of those mics over there.
That's fine. So a comment on Ted's question. What is the plan for Working Group 5 in terms of the choice of law question? Are we going to deal with it generally or in the context of groups? In terms of the decision, it was vague, and I think we decided that the choice of law question is important, but not within the mandate, while dealing with enterprise groups is within the mandate, so perhaps we'll discuss it in the context of groups. But as a matter of practice, and that's my view, as a matter of best practice or good practice, I think we want to be able to discuss choice of law issues in the context of groups without making a decision about our approach generally. Because the two must be consistent. We can't have a rule for enterprise groups applicable law issues that may eventually be inconsistent with our approach to choice of law generally. So if we reach the point where we will want to discuss choice of law in the context of the enterprise group project, we'll have to pause and consider the question more generally. Corporate groups are not different types of structures. It's just an assimilation of single entities. And one question for Bob or for everyone regarding the undertakings. Because you mentioned that with regard to the undertaking, there is another applicable law question. Is it a contract? So should it be subject to the conflicts of law rule regarding contracts? And I'm wondering whether this is overcomplicating this issue to some extent, and perhaps it's unfortunate that they used in the context of the EU regulation the word undertaking, which sounds like a contract, and I use this word as well in my paper and presentation. But what I mean when I use the word undertaking is really application of local priorities rather than giving an undertaking, signing on a contract. And so in terms of the applicable law, I would apply the law of the local forum regarding the priorities within the lex fori concursus. That's what I mean.
Jenny.
As Irit said, it is a little vague, and perhaps it should be left that way. But I think, what I saw happening at the colloquium and the working group in November is there seems to be a growing appetite for doing more and more work, and there's a whole lot of different issues, as you know, we discussed, 5, 6, 7 topics. I think the practical constraint is we have an existing mandate that covers whatever it covers with respect to enterprise groups and directors' obligations. And so what we've said, I think, is within that existing mandate, to the extent the choice of law issues arise, we will try and deal with them. Then, with respect to possible, what we always use the term possible future work, for which we would need to go back to the Commission and get another mandate, there are various possibilities, including choice of law, per se, choice of law project, principles, whatever. But the feeling of the working group was that they were more interested in recognition and enforcement of insolvency-derived judgments than they were in choice of law. So there was a sort of a ranking of the other topics. But I think choice of law was, I can't exactly remember the ranking, but it was kind of up the top. Yeah, it was kind of at the, it was
second.
So it's kind of there. So I think what we need to do at our next meeting in April, because what we said, we were deliberately kind of vague about even the judgments work, was that we would seek a mandate at an appropriate time, because essentially within the Secretariat there's me and a portion of another person. So So we have enterprise groups, we have directors. We have an informal study group on the feasibility of an international convention and broader adoption of the model law. We have people interested in looking at financial contracts. We have people interested in pushing the work on judgments. So it just kind of fits within the realm of how much can you actually do. And we only have 2 weeks working group time a year, so something's got to give somewhere. And whilst I'm quite happy to try and, we can move forward on multiple fronts, some of these issues are really extremely difficult. And, it's not a walk in the park.
So Chuck, and then I'm sorry, go ahead.
The states, the states themselves expressed concerns during the colloquium and during the working session after that group enterprise issues was a critical aspect to move forward on. And so what's going to happen, I think, as we go forward is going to be a choice of laws is going to be balanced within that concept, because part of the issue is how much time do you take to address choice of law, since it's a much more complicated issue. Personally, I think the choice of law will be addressed, but I think it'll be addressed as group enterprise becomes more of a mature project. You get some definition as some of the base areas, and then choice of law then I think will fit in. But there was clearly an expression by the states present that group enterprises need to be addressed in as quickly as possible in an organized fashion. And obviously, as we've talked about before, these projects take a period of time. And Jenny only has so much time. So.
My response to Erit with regard to the undertaking and approaching it as some sort of a contractual concept was just only to display the problems that such an approach would lead to. The basis is in the EU regulation, so we should see it as an autonomous beast, but we should much more further detail it, because if you give me an undertaking in the Netherlands, I need the opening of a secondary proceeding in the Netherlands to chase the directors for fraud. I'm not interested in 80%. I want a secondary proceeding, and I want the bastard for fraud. So there must also be a good interrelation between the union law with further detailing that undertaking and what it takes away on the national level or should include on the national level, leaving that open to decide for national law. We need much more thinking on it.
Okay. Chuck, Adam, we're coming up on the edge of the time, so I'll let Chuck and Gabriel get their questions out, and then...
Yeah, just a quick question for Bob, now that he's had a good night's sleep, and I guess also for our other European colleagues. If we sort of imagine that there's a consensus on a harmonized choice of law rule, and one where the applicable law in a secondary or non-main proceeding would give very substantial deference to the insolvency law of the COMI in the main proceeding, and if we further fantasize that this was widely adopted in Europe, how would that work with the regulation?
And then let's get Gabriel's question out, and then you guys have to keep track of both. Right.
It wasn't actually a question. I was going to say something in response to Bob's nightmare scenario about secondaries. What I want to say first of all is, and this ties into the theme of my paper, which is the idea of what works in practice, which has some importance in the insolvency area. And what I would suggest is that the idea of these undertakings arose out of two cases that I was involved in which such undertakings were given and honored, and they worked in practice. You have to put the undertaking back in its context. What you have to imagine is a main proceeding which covers the entire European Union, the entire business of the group or subgroup, and the opening of a secondary in one of the local jurisdictions would be disruptive to the goals of either rescuing, reorganizing, or beneficial sale. So the main liquidator, administrator, so on, has a meeting with the local creditors and says very simply, if a secondary is not opened, i.e. if you lot don't go and ask for the opening of a secondary, that doesn't rule out other people doing it, but if in fact no secondary is opened, then in the main proceedings, instead of applying the law of priorities in the main proceedings, we will apply, to the extent of the assets that would have been contained in the secondary proceedings, we will apply your local law to the question of priorities. That's perfectly simple. It works in practice. All these problems are I would respectfully suggest, rather academic, but no doubt very interesting in a discussion like this. But on the ground, it does actually work, and that's why the European Commission have suggested it. Parliament should actually stay out of these things because they have no idea what they're doing. But you have to remember the European Union has a very different structure. It's not like Congress. Things are actually put forward by a commission with expert advice. They're actually decided by a council of ministers who are from representative elected governments. And the Parliament gets a little sort of say in that. Unfortunately, the elections in May are probably going to bring people to the Parliament who are so far to the right of the Tea Party that they would probably be banned from entering this country. And what they will make of insolvency law, we've yet to see.
Okay, so you guys get to answer whichever of those two you want.
Shall I try? Well, I learned from Gabriel it's not a question, but a statement, so it's fine. No, I think at the end of the day, you have to define what an undertaking is, because we are not introducing the fine British concept of an undertaking. No, it's something new. We learn from your experience, but I know some of the liquidators in the eastern part of Europe that try to come around it. And I think it should have an autonomous conflict of law rule, and we should have an exclusion in the Rome I regulation, that the Rome I regulation with regard to contractual obligations doesn't apply to undertakings as mentioned in the insolvency regulation. So we have our own package on conflict of law rules in addition to Article 4 or whatever. I think that is the better, my preferred approach.
Chuck? Yeah, so we're going to let Chuck ask that question again because he's on the next panel. We're right on time. It's time to take a coffee break. We'll reconvene at 11:15. We're off to a terrific start. Thank you all to our panelists.